Commissioner Rouleau, for the record, my name is Sujit Chaudhry, and I'm counsel for the Canadian Constitution Foundation. Commissioner, as you look over the evidence and prepare your report, we would suggest that you do so informed by history. In particular, we would invite you to look back at the cabinet minutes of the last use of emergency powers by cabinet before February 2022, the invocation of the War Measures Act in 1970 during the FLQ crisis. These minutes have been declassified and they are in the CCS evidence. At the time, the Prime Minister did not initially recommend that the War Measures Act be triggered. The Security Committee of the Cabinet had met the previous day and were briefed by the security services that there was no apprehended insurrection in Quebec. The Honorable Jean Marchand, the political minister of Quebec, sharply disagreed at the cabinet meeting. He presented unverified intelligence at the cabinet table that the FLQ was, quote, a state within a state and heavily armed. He stated that failure to invoke the act was, quote, meant the risk of losing Quebec. In the end, the cabinet came around to Marchand's view. I have no doubt that Minister Marchand acted in good faith. However, it is now accepted that he and the cabinet were deeply mistaken. There was no apprehended insurrection in Quebec. The security services were right. Cabinet overreacted in the FLQ crisis. It should have relied on legal tools outside the War Measures Act. The basic mission of the Emergencies Act was to make sure that this kind of mistake never happened again. Under the War Measures Act, the Governor and Council had nearly unfettered discretion to determine if an apprehended insurrection existed. On first reading in Parliament, the Emergencies Act only required that the Governor and Council be, quote, of the opinion that a public order emergency exists. In committee, the Act was amended to require that the Governor and Council believe on reasonable grounds that a public order emergency exists. Minister Perrin-Beatty, the author of the Emergencies Act, explained that the shift from an opinion to reasonable grounds test was to, quote, guarantee Canadians the ability that the courts could rule on whether the government had reasonable grounds to believe that a national emergency existed. The same holds true for this commission. Commissioner Rouleau, you must determine whether the Governor and Council had reasonable grounds to declare a public order emergency. We say that you must conclude that reasonable grounds did not exist for two reasons. First, the Governor and Council can only have reasonable grounds to determine a public order emergency exists if it is provided with all the relevant information to enable it to make a proper decision. The government has not established that the CSIS threat assessment was even provided to the full cabinet. There are good reasons to find in the record that it was not. In addition, the government has not established that the February 13th policing plan was provided to cabinet. Second, the proper interpretation of the Emergencies Act is that it incorporates the CSIS Act definition of a threat to national security. CSIS's own expert assessment of this event is that there was no threat to national security. In the face of this finding, the reasonable grounds test requires that the federal government provide evidence for why it disagreed with the CSIS assessment. It is simply not enough as a matter of law to say that the cabinet relied on a broader set of inputs to reach its decision. The invocation of the Emergencies Act has been and should remain exceedingly rare. But now that the glass has been broken on the Act, it can be used again. When the Commission asked hard questions about the Act's use in 2022, it must also focus on the Act's potential misuse in the future and protect the right to protest, parliamentary democracy, and federalism. We thank you, sir, and the Commission Council for your exceptionally hard work, and we look forward to continuing to work with you until this process is concluded. Thank you.
Okay, thank you. The Canadian Civil Liberties Association.
Commissioner. Harris Weeble on behalf of the Canadian Civil Liberties Association. In February of this year, for the first time, the Government of Canada declared a public order emergency and put in place emergency measures that restricted the rights and freedoms of all people in Canada. These measures placed broad restrictions on the freedoms of Canadians to assemble and protest. They allowed for the government to compel the provision of services and for personal assets to be frozen with no notice and no due process. These orders handed law enforcement agencies and financial institutions extraordinary powers. The government may have intended these powers to be used in targeted ways, but as drafted, they gave law enforcement across the country measures whose application went well beyond the blockades and could easily have been abused. I have three submissions. First, the Emergencies Act does not allow for the suspension of charter rights, but without the existence of a public order emergency, the measures that were enacted would most certainly be contrary to the charter. In the absence of circumstances amounting to a national emergency, they would constitute serious restrictions on fundamental rights and freedoms that are neither reasonable nor justified in a free and democratic society. So the question, was there a national emergency that justified these measures, is a crucial one. The Canadian Civil Liberties Association respectfully submits that this question is important, not only for what it says about the events of January and February of this year, but also because of what it signals to future governments about when parliamentary process can be bypassed to allow the government to rule by executive order and when extraordinary powers can be used. Second, the Government of Canada has offered a range of justifications for its decision to invoke the Act. Its primary justification, articulated when the Act was first invoked, is set out in its Section 58 report to Parliament. Although that justification has evolved over time, its core elements are relatively simple and remain mostly intact. The justification focuses very heavily on economic disruption and harm. It also references concerns about the possibility of serious violence, either because of the presence of some violent extremists amongst otherwise non-violent protesters, the possibility that the protests would provide a cover for a lone wolf attack or allow threat actors to recruit, or the concern that violence would erupt in clashes with counter-protesters. Apart from the economic concerns, the evidence on which the government relies to back up these claims is extremely thin. The law enforcement and intelligence agencies, whose expertise should help inform the government's decisions, did not assess the protests as giving rise to a serious threat of violence. The most dangerous element we've heard about, the cell in Coutts, Alberta, with a cache of weapons, was investigated and arrested by law enforcement prior to the emergency orders coming into effect, without the use of any extraordinary powers, and without setting off a chain reaction of violence amongst protesters. The Emergencies Act was carefully crafted to avoid the excesses of the War Measures Act that preceded it. Parliament intentionally identified a public order emergency by tying it exclusively and exhaustively to the definition of threats to the security of Canada found in the CSIS Act. This definition does not include economic harm or disruption, nor should it. It requires activities directed toward or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective. The legal threshold to make use of the Act was not met, and a creative and privileged legal opinion from the government that says otherwise doesn't make it so. The Prime Minister agreed that the threshold is no lower to invoke the Act and restrict the rights of all Canadians than the standard set out in the Emergencies Act to investigate and surveil a single individual. In our submission, the government exceeded the bounds of the law in taking the steps it did. Finally, there's no doubt that the blockades and protests gave rise to serious harms to the people living in communities where they occurred, that they caused significant economic disruption, and that law enforcement agencies were not well prepared to address them. The government, various governments, were struggling to get clear information from law enforcement about its plans and were wary of crossing the apparently still blurry line that risked undermining police operational independence. But the government also felt a great deal of pressure to do something to address the situation and to be seen to be doing something. Instead of establishing clear and appropriate lines of communication, having frank discussions, and putting instructions about strategic priorities to police in writing, the government gave law enforcement the biggest and most public nudge it could. It invoked the Emergencies Act and handed law enforcement across the country sweeping and unnecessary new tools and a clear political mandate to use them. One of the CCLA's core values is equality, and specifically the belief that the freedom of no one is safe unless the freedom of everyone is safe. We urge the Commission to bear this tenet in mind as it examines what the government did and considers what future governments may do. Thank you, Commissioner. Thank you to Commission Council and to my friends.
Okay, thank you. And now the Justice Center for Constitutional Freedoms, Democracy Fund, and Citizens for Freedom.
Commissioner, my name is Alan Honor and I'm counsel for the Democracy Fund, but I'm also addressing you on behalf of the JCCF and Citizens for Freedom. But we'd like to express our gratitude for this opportunity to participate in these proceedings. At the commencement of these public hearings, we stated that our goal was to get to the truth about why the government invoked the public order emergency. We wanted to hear evidence about whether the government met the legal threshold for invoking the Emergencies Act. And Commissioner, we have heard we've heard evidence on many issues, but the reasons why the Emergencies Act was invoked is the primary and ultimate issue you should turn your mind to. I won't repeat the test for declaring a public order emergency because we've all heard it so many times, but I would like to address just one part of that test: threats to the security of Canada. In one way, this is a very high threshold for the government to meet, because threats to the security of Canada means more than ordinary threats or acts of violence. The definition requires serious violence or threats of serious violence for the purpose of achieving political, religious, or ideological objective. In our written submissions, we'll be looking at, among other things, the definition of terrorist activity is set out in the Criminal Code and how it is similar to the CSIS definition. And in fact, some of the CSIS documents that were disclosed to the parties through this inquiry show that CSIS refers to Section 2C as terrorism and extreme violence. And this reference is indicative of just how high that threshold is. We submit, and the Prime Minister's evidence left little doubt, that this very high threshold is the same whether it applies in the Emergencies Act or the CSIS Act. The context, the decision maker, and the purpose are obviously different. There may even be different inputs, but those inputs are meant to answer the same question. Are there threats or acts of serious violence for political, religious, or ideological purposes? And that is the one and only standard. Commissioner, I've made reference to how high the threshold is, but in a different way, it's a low threshold. And on the issue of threats to security of Canada, it doesn't require, for example, proof beyond a reasonable doubt, nor does it even require proof on a balance of probabilities. The threshold only requires the governor and council to actually believe that there are threats to the security of Canada, and it requires that belief to be reasonable. Respectfully, we submit, and we will argue in detail, that the government has not even met this low threshold. There may be reasonable grounds to believe that some acts of violence were happening. Ripping off masks, police officers being swarmed, eggs being thrown, coffee being thrown. These and other things may have happened in the protest, which was of unprecedented proportions. And let me be clear, that is not acceptable. But those acts do not rise to the level of violence or threats which are required by the Act. And further, they do not reflect the attitudes, actions, and values of the vast majority of peaceful protesters. Even the most significant threat we heard of, which was the presence of weapons in coups, does not meet this threshold. And even if it did, it was neutralized. Those alleged criminals were sitting in an Alberta jail when the Emergencies Act was invoked. The threshold requires present threats, not past threats, not fear of the unknown. Canadians and even the international community are and will continue to be divided over the Freedom Convoy protests. Canadians will also be divided over future protests. As one of my friends aptly observed, tomorrow's protest could be about environmental issues, or it could be about some other political cause. To safeguard democracy, the rule of law, and the cherished right to protest for everyone, no matter what you believe, we must ensure that the Emergencies Act is only used as a last resort in the direst circumstances. Our detailed submissions will follow. We'd like to thank you again, Commissioner, Commissioner Council, and Commission Council, and the parties.